So thanks everyone. We are going to start another study group of LexDAO. This is about MiCA. I mean, MiCA is MiCA. There's a debate also about that. It's the new. We are all proud as Europeans of this new crypto law. I mean, we are probably the big political group in the world. Of course, there are tiny islands like Cayman or BVI, but in terms of big political entities at world level, we are probably the first one, I think, that have a crypto law, a crypto legislation. And I think for that should be praised, probably the European Union. Of course, there are a lot of problems in MiCA. A lot of things can be said. A lot could be much better than what is. But still, in my very personal opinion, is at very least it was. We can praise the European Union for having the courage of starting as a big entity, of course, because on the other side of the ocean, I mean, they still have Gary Gensler with the SEC trying to put together a case law decision after decision against token holders. So we are somehow proud of this. There are various things in MiCA, and the first two titles of MiCA entered in force very recently at the end of June 2024. And I personally decided to concentrate the study group about tokens. Because in MiCA, as I was saying before recording, there is also the CASP regime, which is very much important. CASP, crypto asset service providers, is very much important. There are a lot of issues in the crypto industry, but at least very much personally think that also is for the crypto industry in general, it's very important to understand the token, the legal regime of tokens. A lot can be said about tokens, and ultimately, crypto is about tokens. The real brick of crypto are the token assets, the crypto assets. So MiCA has Title 2, which Francesco will speak about it, and about utility token, but really the definition is more complex than that. And then we are Title 3 and 4 about ART and EMT, which are basically the stable coins. Peter will speak about that. And also the NFTs are not covered by MiCA, but somehow they are included in MiCA. So Alvin will speak about that. And then we have Marina and Chiara from UCI, can I say a lobbying group, a lobbying group pro crypto. So Chiara will give us an introduction about MiCA, and Marina will try to give us some behind the curtains of maybe what happened about MiCA, what could be better or worse. So I will start with Chiara, and if you could please give us an overview of MiCA, considering that as LexDAO is in principle international, but the majority of the members are probably from the US. So what is MiCA is very much unclear. And I would say starting from the difference in the European Union between a directive and a regulation, which probably many non-EU lawyers don't have clear. So thank you. Please.
Thank you, Paolo. Yes, with pleasure. And I'll be mindful that not all listeners might be very much accustomed to the specifics of our regulatory system. So starting from the basics, what is a regulation? A regulation, in theory, at least, is a directly applicable act by the European Union. It's the way that it's being created is usually by a proposal by the European Commission, that is the executive body of the European Union, and then it goes through a very sometimes lengthy, in the case of MiCA, process of negotiations where the two co-legislators, which are the European Parliament and the Council of the EU, negotiate the text, after which it's finalized, it's voted by the two co-legislators, and it's published in our official journal of the European Union. After which, it's, as usually is the case with such official journals, especially in the EU, there is a gap between the publication and the entry into force, which is 20 days when it comes to regulations, after which it becomes applicable unless it's stated that there is a delay in that application, which is the case with MiCA. And as Paolo mentioned, that delay is in 2 phases, with the first one already kind of a reality from the 30th of June. When it comes to stable coins, that part is already applicable within the EU, and the rest of the MiCA, of the marketing crypto assets regulation, would become applicable on the 30th of December. And the difference between, because some of you might wonder what is then the difference between a directive and a regulation. A directive goes through the same process, legislative process, proposal by the Commission, negotiations, votes, but then it has to be implemented within the local member state legislations in order for it to be applicable. So the European Union comes up with this text that then the member states need to kind of make used to and integrate within their pre-existent legislative frameworks. The current trend, especially when it comes to financial laws, is to slowly but steadily move towards more a regulatory approach, an approach based on regulations, with the main idea being that we need to have a truly unified legal framework within the EU, especially if we are actually aiming towards creating this common market for goods, services, and so forth. So when it comes to especially financial services, from which now the crypto assets industry is more and more becoming a part of, it is mostly regulations. But there is a sort of a, I would say, a bit of a misconception when it comes to the direct application of regulations. And I don't want to make this too kind of legally complex, but there still needs to be an adoption on a member state level, which would still require a national law that would implement basically the regulation, and not that much to implement the specific requirements that are in the text, but to mostly establish which are going to be the competent authorities that would then supervise for the implementation on a member state level, which at the end of the day is still the first kind of point at which the implementation and the legal basically compliance is judged. So this, particularly at the moment, we at the UCI are following that, how member states are adopting MiCA within their legal frameworks. We have this nice table where we track everything. It's very kind of a living creature that we update very often, because member states keep us busy, because they're still in the process, some of them, of even adopting the stablecoin parts. But what's important is that they still have some discretion when it comes to fees for registration, but also the member state needs to point out which would be the national competent authority supervising and also issuing the licenses under MiCA. So when it comes to the type of national competent authorities, it also varies. Sometimes it's just the national bank, sometimes it's the local financial authority. So it needs to really be part of the discretion of the member state, because there are differences in the overall financial market regulation within member states. So that's the difference between a directive and a regulation in a nutshell, and that's what matters when it comes to MiCA. And some, I think, interesting anecdote that would serve as a nice beginning of this conversation that we'll be having on tokens and crypto assets is that basically how MiCA came into existence. Obviously, there were already interest coming from regulators towards the crypto asset market, with all the activity, with all already instances of certain accidents and different, especially when it comes to centralized exchanges, different collapses of such exchanges. But in 2019, when even 2018, when the Libro project, some of you might remember this attempt by the then called Facebook, currently Meta. So the Libro project was being established, and what the representatives from the Libro project basically decided to meet with representatives from the EU institutions. And the anecdote goes that they basically went there and said, hey, your financial system is very flawed, so we come here with this solution on how to fix it. And the reaction was basically, I'm paraphrasing again, it wasn't there, but was, we need to regulate this. That's really concerning. So this also explains why there is such a big attention towards stablecoins in MiCA, something that I believe would also be mentioned by the other speakers. But it all began by this attempt to create a stablecoin that would then have kind of put too much control into one centralized entity. And going back to MiCA, it's all reflected in there. You can basically see, and it's going to also be mentioned, I believe, during the discussion, but it's aimed at centralized entities, mostly when it comes to crypto asset service providers. And it's aimed mostly when it comes to crypto asset, to what is happening with them following the issuance, who is basically providing services with them. The exceptions being e-money tokens, but that's another topic. But basically, it's very focused on the centralized concept of control and custody. So this is also, you can see it from the list of crypto asset services that are in MiCA. So on the one hand, we have that, but on the other, we also have the rules around crypto assets. So that makes MiCA what it is. It's very, as you, Paolo, mentioned very rightly, it's a crypto asset focused regulation that has in mind specific issues that were back in 2018, 2019, that were concerning for the policymaker.
So thank you very much for this overall description of MiCA. So, sorry, I have some glare. Francesco, so could you speak about Title 2, which is in principle, we all call utility token, but in reality, it says tokens which are not AERT or EMT, so the definition is negative. So could please speak about Title 2, which type of tokens are disciplined under Title 2, and in a nutshell, which is the discipline of these tokens? Thank you.
Yes, okay. So I start from the very definition of tokens that are under Title 2, which, to be honest, is not there. So there is a definition in MiCA that deals with crypto assets more in general. They are defined as a digital representation of a value or a right that can be exchanged on DLT or a similar technology. And this applies to every sort of crypto assets, financial instruments, or assets that undergo MiCA. And so a first indication is understanding what is excluded from the scope of MiCA. And the point of reference is Article 2, Paragraph 4, where there are financial instruments and several others instruments regulated under EU law. And if the crypto assets is something that can be qualified in accordance to these rules, then it's outside of the scope of MiCA. And so what is inside the scope of MiCA? We have basically three categories of tokens. We have the asset reference tokens and the e-money tokens, Title 2 and Title 3, that will be explained afterwards. And then we have a third category that is explained only in a negative way. And you mentioned it before, Paolo. It's tokens other than asset reference tokens and e-money tokens. And it's interesting because now in the parlance of the European juridical thinking, and I'm referring especially to a publication of the Italian Banking Authority of yesterday, like in order to identify the tokens that undergo Title 2, you speak of other tokens. So other tokens is now the kind of official denomination for these tokens. And so the question is, what do we find within these tokens? We find for sure the utility tokens that are defined within MiCA. So it's we can say it's like a subcategory of other tokens under Title II, which is defined as tokens that give access to a service or to a good. And so this would be the utility token, a service or a good that is provided by the issuer of the tokens. And so this is the category of utility token. But this category of utility token in reality is not of great use, because it's just a category that allows you to be exempted from certain rules of Title II. So it's not, let's say, an important category for the industry. It is more a category that perhaps allows you to state that you are inside of this Title II. And so the main question is understanding when you are within the scope of MiCA and when you are outside the scope of MiCA. And the problem is understanding when you deal with an instrument that is regulated under EU law, under a law that is not MiCA, and especially MiFID II that deals with financial instruments and securities. We would use this name under US law, or a token that, let's say, it's outside of the scope of application. How do we define it? And this is a bit, I would say, one of the weaknesses of MiCA is the fact that there aren't really criteria to distinguish between these two categories of tokens. Why not? Because now we have an harmonized framework when it comes to crypto assets under MiCA. But with respect to financial instruments, we do not have an harmonized framework. We have national legislations that are based upon a directive, which provides some indications that results, objectives that need to be implemented at a national level. But there is an understanding which differs from country to country. So which is the point of reference from a practical point of view? We have some guidelines that were provided by ESMA in order to address when the token is outside of the scope of application of MiCA. But these guidelines were a bit, I would say, disappointing, because they provide little guidance. They indicate only some high-level indications. And now, in that news of the last weeks, we have other guidelines enacted by ESA, so by the three authorities that are important at the European level, EBA, ESMA, and the Insurance Authority, that basically indicate how to assess if the token falls under MiCA or if it falls outside of MiCA. And it's like a long document that has also a very nice diagram that was posted on LinkedIn by a lot of people. And so I'm sure that everyone has seen this diagram. I would say that the main problem of this diagram is that you need to assess from a negative point of view, like if the token falls within the Title II. And so you have first to assess if the token is an asset reference token. If the answer is no, you go on, e-money token, answer is no. Then you go through the categories that are regulated under European law. And so first, financial instrument, tradable security, and then like all the other categories, pension fund or participation in a fund, an investment scheme, and whatsoever. If the answer is always no, then you're going to have a token that undergoes MiCA. And so it's quite difficult really to do this assessment. And I would say that the main problem is that this guidance, and I think that this is wrong, makes not only reference to European law in doing this assessment, but also to national law. And so it means that in order to be sure that the token is regulated under MiCA, you need also to address the problem at a national level, which is a bit a surprise, because in theory, MiCA should be regulated at in a harmonized way at a European level. So now I'm speaking a lot. Just a few words on the regime that is under Title II. So let's assume that now we have our token that goes under Title II. We are sure about the assessment. And like in a practical way, I can say that you have this kind of token if you don't have a reward that is connected to the token, and you don't have a decision making mechanism, so a system of governance that let you decide upon how much reward a token holder would get. And so we're talking about tokens that can be, for instance, layer ones tokens that are used for fee payments, tokens that are really connected to the access of certain perks, for instance, fan token of a football team, or tokens that are mere governance tokens, a bit the DeFi style tokens, as for instance, Uniswap, for instance, could be if there isn't like obviously a reward switch in favor of the token holder, could be considered under Title II. In a nutshell, what is the regime? If you are within Title II, there is the possibility of doing a primary sale of the tokens in publishing a white paper and notifying this white paper to a national authority. And the white paper is not really a prospectus, so you have to provide less information than the one that you provide when you launch a financial instrument. But nonetheless, it is something which requires a hard legal work, and especially in defining and indicating why the token is not a security. You don't have to undergo this mandatory disclosure regime if the token is a utility token, and so there is really the possibility of accessing a service, and this utility is already in function. So if at launch, for instance, the DLT platform is already functioning, in theory, you can do a primary sale without publishing a white paper. But the regime becomes again applicable if you demand as an issuer or offerer, if you demand access to a trading platform, because in this case, the idea is that the token has also, I would say, a more financial function, and therefore you need also there to notify the white paper to an authority. What is this notification? So it's not really an authorization regime. You don't get an authorization by the authority, but it's a non-objection regime where you have to wait 20 days and then it's fine and you can start with the sale of your tokens. And theoretically, you can pick the national authority that you prefer and identify this national authority as the home authority that will deliberate on the tokens. And then from there, you can also indicate other European countries where you want to sell the token. And so it is questionable, whereas there will be some sort of arbitrage in choosing the authority, given that this assessment is the token under MiCA or not, is an assessment that in part depends also on the national law, if we take this ESA guidelines seriously. And then I would say finally, you have also rules on marketing, and so on the marketing communications that people can provide. And also this is strictly regulated because you have to indicate some mandatory disclosures, as for example, the token can go to zero. And then there is also a reference that has to be made to the white paper. So there is this connection. If you want to provide advertising for your token, you have always to refer to the main document, which is the white paper. And finally, there's also a kind of very tricky provision that deals with withdrawal. And that's a very European stylish legislation that allows the retail investor to withdraw from the investment. But this is possible only if the token is not yet tradable on the market. So in this case, you have this cooling off period of 14 days, which is kind of new in this sector, but you need to allow the users, the retail investors, to withdraw from the contract. And finally, there's also a liability regime in cases in which the contents of these white papers are not well drafted, so there are gaps or information that is not correct. In theory, the offerer, so the person that has published the white paper, undergoes liability and so can be sued for repaying the damage. And it's a liability regime that can apply to the issuer if the issuer is also the person that offers the token, or it can apply also to the trading platform, depending if it's the trading platform that has published the white paper. And what is said is that probably the trading platforms, so I'm referring to players as, I don't know, Binance, Coinbase, they will never take the responsibility for publishing the white paper because they don't want to undergo this liability regime. But I think I spoke too much, so I give the word back to Paolo, and it's on you. Bye.
Thank you, Francesco. This very detailed description of other tokens. That was very good. So now the floor is to Peter. So you have the big meal, I would say, the main course, which is ART and EMT. So I didn't know the anecdote that Diara just told us. So it was very interesting. So yes, please, can you speak to us about the ART and EMT? Thank you.
Yeah, for sure. Thanks, Paolo, by the way, for organizing this. It's nice to be here. So Viara already made my job a bit easier, actually, by doing her introduction, because she talked about how MiCA is a very stablecoin heavy regulation, I would say, and that happened exactly partially because of this anecdote, and because when Facebook came with this Libra or DM project to the European legislators, it kind of sounded the alarm bells, and they really kind of, when they were drafting MiCA, they were thinking, I think, about, I mean, Marina or Viera, of course, you are the policy expert, so if I'm wrong, you can correct me, but I think they were thinking about European monetary sovereignty and stability, which is something that could be at risk if, you know, big techs or other big actors essentially just issue their own currency that could be a competitor to the euro, and that's why they focus so heavily on stable coins, and that's why the regulation engages less on, you know, the concept of DeFi or decentralization or NFTs even, that are omitted, or are they? We will see later on. So titles 3 and 4, which, as we are also mentioned, are already applicable since June 30th. They essentially describe the regulation of two categories of stable coins that the EU legislators kind of invented. One of them is e-money tokens. That is a type of crypto asset that maintains a stable value by essentially referencing the value of an official currency. And then ARTs, which are asset reference tokens, which are a crypto asset that is not an EMT, but that maintains a stable value by referencing another value or right, or a combination of, so essentially this can include multiple official currencies. So an example of an EMT, I guess the best one is currently the only licensed EMT, which is a Circle. This would be the biggest part of the stablecoin market that we know, I would say. And then asset reference tokens would have been something like the case in point DM or Libra, which would have referred to essentially a basket of different official currencies, and it would have essentially maintained a stable value compared to those official currencies. And then at first I will talk about EMTs, because I think that it's sort of the more significant and more discussed category of stable coins. It's definitely the juicier one, the juicier topic, as we will see later. So the scope of MiCA is applies to natural and legal persons engaged in the issuance or the offer to the public or the admission to trading of crypto assets and related services. And Article 48 of MiCA essentially mandates that anyone that wants to issue, offer, or admit to trading an EMT must be licensed as a credit institution or an EMI, and they must also notify the issuance to their national competent authority, and they have to publish a white paper. And then there are a number of essentially prudential and safeguarding requirements that are specific to EMTs, and these are also similar with a couple of changes for ARTs. And these prudential requirements are things that we have kind of seen previously in European legislation, whether it comes to prudential requirements in relation to e-money institutions or even payment service providers or credit institutions. Also, although I would say that still EMT prudential requirements are a bit less stringent. And then there's also requirements for the white paper that are in Article 51. So essentially the white paper is like a disclosure statement, and these statements will be standardized by the European Banking Authority and the European Securities and Markets Authority. And then they need to include things like the information about the issuer and the offerer, the rights and the obligations that the EMT grants to the holder, the risks attached to the EMT, the underlying technology that is used. Also, there's a bit on the climate implications, which is kind of a remnant of the EU's like focus, green policy aims, and also the debate that kind of comes from the proof of work debate when people are saying that Bitcoin is 10% of the world's energy usage and such well, kind of nonsensical arguments. And then there's also disclaimers essentially that need to be included in the white paper that ensure that the holder knows that when they hold the EMT, they don't fall under the deposit insurance scheme of the EU or to the essentially investor compensation schemes. And then there's prudential requirements that, for example, 30% of the funds received for issuance need to be invested in separate accounts in credit institutions, and the rest has to be invested in low risk, stable, highly liquid financial assets. And then there's also this concept of significant EMTs and ARTs, where I think that if there's a list of conditions and if your token satisfies 3 of these conditions, then you'll be considered a significant EMT, and there will be an increased essentially compliance regime that you'll need to go through. So these conditions are things like if there's more than 10 million holders of your EMT, or if the market cap of is bigger than 5 billion euros, if the daily transaction volume either in euro terms is bigger than 500 million euros, or the number of transactions is bigger than 2.5 million euros. And then there's a bunch of other conditions that are a bit more general, I would say. So for example, there's a judgment of the interconnectedness of your EMT with the financial system, its international significance, as well as whether the issuer of the EMT is a gatekeeper who has essentially provides core platform services under this other act of the EU, which is the Digital Markets Act. So that's also kind of a play on big techs, because most of these gatekeepers, they would be the likes of Facebook, Meta, Alphabet. So it's kind of trying to keep them in order, I would say. And then the next part that's really interesting about EMTs is this interplay with a prior concept under EU law, which is e-money. So e-money is regulated by the e-money the second e-money directive, and the definition of e-money is essentially an electronically including magnetically stored monetary value represented by a claim on the issuer, which is issued on receipt of funds for the purposes of making payment transactions. And EMTs and e-money, they're very similar concepts, but they're not the same thing. For example, an e-money must represent the claim on the issuer, which we will discuss later might not always be the case for EMTs, while the definition of EMTs includes a reference to the value of an official currency. But there are so many common characteristics, like they must be issued at par value to the funds received. There's a prohibition on interest. There's a right to redeem at par value. And actually, Article 48 of MiCA states that e-money tokens shall be deemed to be electronic money. And it also states that e-money tokens that reference an official currency of an EU member state shall be deemed to be offered to the public in the Union, meaning that they will have to be licensed as an EMI or a credit institution to issue that EMT. And this creates this very interesting interplay between the e-money directive and MiCA, because actually the Title 2 and Title 3 of the e-money directive applies to EMTs. So that's essentially on the prudential supervision of e-money and the issuance and redeemability. So it applies to e-money tokens unless MiCA states otherwise. There's, for example, also an exemption for smaller EMT or e-money issuers that is included in Article 9, but applies to EMTs as well, where if the total issuance is less than 5 million euros, then you don't have to register as an EMI. So why this is very important is because under the current Payment Services Directive of the EU that essentially regulates payment transactions in the EU, payment transactions have to be carried out with funds. And the definition of funds includes e-money, which would mean that if EMTs are considered e-money, well, then they are included in this definition of funds. And there's not that much clarity on that yet, but the Payment Services Directive is currently being reviewed. So there's a proposal that is, I think, with the European Parliament and the Council already. So there's been a proposal from the Commission. So this is a proposal that's subject to change, but there is a recital included in it, recital 29, that essentially says that MiCA lays down that electronic money tokens shall be deemed to be electronic money. So electronic money tokens are therefore included as electronic money in the definition of funds. So if this change stays in the current draft or in the official draft that will be published for the payment services regulation, that will clarify this topic somewhat. And then I'll quickly talk about asset reference tokens a bit, because it's a bit quicker, and then I'll go back to some interesting discussion about EMTs. So as I said in the beginning, asset reference tokens are a crypto asset that essentially references the value of a value or a right or a combination thereof that can be one or more official currencies as well. So essentially, ARTs are kind of a new instrument of exchange that is subject only to MiCA. So there's not this interplay with the e-money directive like there would be for EMTs. And most importantly, ARTs, they definitely won't be regarded as funds for the time being. So they can only be used as a means of exchange and not for payment transactions. And the holder of an ART also has like this right of redemption, but the right of redemption is a bit different because you need to redeem it as the issuer for the par value of the underlying asset of the asset reference token, either in fiat, so the underlying value in fiat, or in the actual reserve asset. And then there is kind of different additional requirements for ARTs that are not there for EMTs, and that's kind of a choice by legislators in order to avoid that some ARTs, exactly like Diem might have done so, become too essentially too commonly used as a means of exchange. So there's, for example, a higher reserve requirement. So I think it's 60%, and it needs to be held in separate credit institutions. And then there's public disclosure requirements on the underlying composition of the reserve assets used. Then there needs to be kind of policies on a stabilization mechanism for ARTs or the underlying reserves. And then there's also kind of these mandatory audits that need to be done every 6 months that are, well, that's actually also relevant for like significant EMTs, but so that's that's kind of a more stringent prudential requirement for ARTs. And so then I'll get back to this interesting debate on EMTs. So there's essentially a debate whether EMTs can only be issued by authorized e-money institutions or credit institutions, or whether an EMT, or whether there can be non-EU currency stablecoins that reference an official currency. So that means an official currency is a currency issued by a monetary authority or a central bank. It doesn't have to be an EU member state. So that reference an official currency, and this stablecoin does not seek to issue or offer to the public or admit to trading this token. So actually, there was a very interesting talk organized by Marina and Viara, where and the European Crypto Initiative, where Jonathan Gallet and Dimitris Psalakis, who are both very good experts on stablecoin regulation, they discussed this topic. Because if there was this EMT that does not seek to be admitted to trading or offered to the public, and it's not an EU currency, well, then it still fits the definition of an EMT, but it's uncertain whether it would fall under Title 4, so it would be regulated under Title 4. And then obviously, because it's not, it wouldn't have to be issued by an EMI. So then the whole, my prior explanation about EMTs potentially being considered funds under PSD2, well, that all goes out the window as well. So that's an interesting discussion. And then to finish, because I think I've been speaking a lot, but there's also a lot to get through, I guess. We can see, as Viara also mentioned, actually, in her introduction, that it's, I think MiCA is quite favorable to centralized stablecoins, just by virtue of the prudential requirements, the need to identify as well the issuer or the offerer, and also it kind of creates an environment, in my opinion, that aids incumbents in the current European markets. So, for example, I mean, I know that Tether currently is kind of deciding whether they should come in and register. However, Circle has already registered, which kind of makes them a very valid option. And essentially, there's a risk that instead of MiCA really creating a diverse stablecoin market with strong European stablecoin issuers, actually, that instead there's going to be this market where overseas stablecoins and or stablecoin issuers are essentially dominating the European market, which I think would be somewhat of a policy failure from the side of the EU legislators, because other than ensuring monetary sovereignty and security of the financial system, their aim was also to promote the creation of this European stablecoin market by European stablecoin issuers. But if these smaller issuers have trouble complying because the rules are too stringent, if they can't get any market share because the incumbents are already too strong, then all this European-based innovation might essentially falter. And to add to this, there's currently also the CBDC project of the European Central Bank, the digital euro, which might in some way become some sort of public market competitor to stable coins. I mean, previously there was no talk of actual integration of the digital euro with public blockchains, but I think from what I saw from the proposal, because this digital euro regulation is also in a proposal form currently, I think there's already suggestions from the European Parliament that there should be integration with public blockchains of the digital euro, which would essentially open the door up to the digital euro existing on public blockchains as well. So I'm not sure if maybe Marina or Viara know more about the current state of this legislative process, but that's also something to keep an eye on. I think that's pretty much it. Yep.
So thank you very much. This was very, very much interesting. I mean, at least myself, I didn't know a lot of stuff about e-money and e-money token, the relationship. That was very interesting. I have a comment, but I think I will make it later after all the speech. So the floor is to Elvin. So basically, NFTs are not disciplined by MiCA, but then recital 10 and 11 really tell a different story, at least in my opinion. So so what's your take about NFTs and MiCA? Yeah, thank you.
Yes, thank you, Paolo, and thank you for organizing this. It's a brilliant event, and learning much by listening to the others as well, I have to admit. So yeah, there's this a common misconception about NFTs and their position in regards to MiCA. And I mean, this misconception makes sense because it follows from Article 2, Section 3, that MiCA does not apply to crypto assets that are unique and not fungible with other crypto assets. So of course, initially, and to some extent still, people still believe that NFTs are excluded. Now, as you touched upon, recital 10 and 11 is key here. And it follows from the recital that this notion of unique and non-fungible crypto assets, it's very limited. It includes digital art and collectibles, and also crypto assets that represent, for example, services or physical assets. So we're talking maybe about product guarantees or real estate. And the primary key here is that the intrinsic value is attached to the unique characteristics or the utility it gives. And also, I would say that the financial opportunity is somewhat limited because the asset is maybe more it's less liquid, it's more illiquid. Now, so if we then look at what the recital says of what is not considered sufficiently unique and non-fungible, it's clear that fractional parts of our crypto assets are not considered sufficiently unique. Similarly, tokens that are issued in a large series or collection, this indicates fungibility of the crypto asset. And then also, even if, let's say you have a non-fungible asset, a unique asset, but if you start attaching features to it or maybe benefits, those processes could make the NFT then become fungible or not unique. So this follows from the recital. So what conclusions can one draw from this? Well, basically, it doesn't matter if the token is issued, if the NFT is a ERC 721 or 1155 token and issued as a NFT as the industry knows it. This is a substance over form to determine fungibility and uniqueness. So we're always looking at the value that is represented, and then a plethora of other objects. Now, I mean, albeit the NFT market has somewhat died, it's very small compared to what it used to be during the bull run. I still believe it makes sense to look at it because, you know, it's still quite liquid, and there are still, you know, collections that have high turnover. And NFTs are, as most of us associate them with and still trade with them, are many of us know these blue chip NFTs, the Bored Ape Yacht Club, maybe Doodles, Azuki, Punks, World of Woman, Moonbird. So these are all NFTs that just have very high values. And if we just look at these collections in general now, most of these collections are launched in series between maybe 5K and 10,000. And they have sort of this box of different attributes that have been randomized. And when you randomize, naturally, there are some attributes or some tokens that represent the same picture with very similar attributes. So if you look at the Bored Ape Yacht Club, which is still one of the biggest collections, there are some JPEGs, which is what's represented on the NFT, that have more or less, I wouldn't say identical, but to some extent identical. Like the only thing that actually differentiates token 4,300 from token 9,000 is maybe the background color. Otherwise, the ape is very similar. Now, if we go back to what the recital says, these tokens are issued, right, in a large series. The Bored Ape Yacht Club is the 10K, and they represent pictures of monkeys or apes. So let's say you present this to a regulator. At a first glance, they will just say, okay, but they're just representing different pictures of apes, and they're issued in a large series, which indicates fungibility. So what other attributes can we look at? Obviously, I would say price has some sort of impact, but when you look at these collections, mostly there are these, a clear majority of the collection is considered a floor NFT, which basically means that it's represented by the current value at the time being, and if you were to sell it, you would get the bare minimum. Then obviously you have certain rarity aspects in these collections, where maybe a golden ape will go for 10 times the price. This is maybe something a regulator would look at, that might even suggest that there is some sort of fungibility, but these are just a small aspect of the overall collection. Then the other thing we need to look at is what attributes or features or benefits are linked to these tokens. Now, if we stay on the Bored Ape Yacht Club, but this is, once again, this comment applies to almost all blue chip NFTs. So all Bored Ape Yacht Club holders receive the same benefits. So they got access to mutant NFTs, they got the ape airdrop, they get access to clubhouses, they had the other side mint. So these assets are more or less treated the same by the issuer, which is Yuga Labs. They're not treated as individual assets, right? Once again, we have something that indicates fungibility. And I'm certain that all of these blue chips will be considered crypto assets. And because they will be considered crypto, or they will not be considered unique and non-fungible, which means that they are fungible, which means that they will be crypto assets subject to MiCA. Now, or then, as Francesco put it earlier, other crypto assets. So what will be the implications of this? Well, Francesco touched upon it earlier. There are some requirements, of white papers. Of course, there are limitations to this as well. If the offering is not substantial, I think it's less than 1 million euro over some certain period, then maybe you can get away from this requirement. But what's really interesting is, obviously, for me at least, I'm very active still in the NFT community, and I trade and I monitor the prices on a daily basis. And two things I find very interesting when it comes to MiCA and the NFT space is that market abuse will not be allowed under MiCA. And by market abuse, we're talking about market manipulation and insider trading. Now, for those of you who are active in the NFT space, you will know that these are two very common occurrences still. So there's always leaks of insider information in the NFT space, and we can see this, for example, in different acquisitions where the collection prices start rising significantly before any news have been published. We saw this with Yuga Labs' acquisition of Moonbirds. We've seen it previously in other cases, similar with Doodles and when they were supposed to release big news. The other aspect of this, which I find really interesting, and this is also something that CASPs need to be considered, because CASPs are the one that to some extent will need to to prevent these circumstances, it's that market manipulation will be prohibited. And if we look at what market manipulation entails, it's obviously a bunch of requirements, but one is giving or likely to give false or misleading signals as to the supply or demand or price of a crypto asset. Now, I don't know how many of you are, active and are familiar with Blur or OpenSea, but on these marketplaces, they are overrun by bots. Bots are trading, and what these bots do is that they, I would say, almost very fast. What they do is they provide liquidity. And for example, on Blur, if you provide liquidity, i.e. you make bids on different NFT collections, you get points because you're a liquidity provider, and Blur wants to incentivize its liquidity providers. However, many of these bots also have as a routine to withdraw their liquidity if someone is actually trying to sell into them. Now, could this occurrence be considered market manipulation? Because technically you're providing, you're giving a false sense that someone here is willing to pay this price for this NFT, but as soon as someone is trying to accept it, because most of these collections are still traded on Ethereum, they have time to withdraw their front run their acceptance by withdrawing their liquidity. Now, I personally think it will. Then it will also have a huge impact on the general PvP element of NFT trading. I don't know if many of you are familiar with Hongwei. He's a famous NFT trader and Blur farmer. And what he did, quite interesting anecdote, he acquired a certain trait of Azuki's, which Azuki is an NFT collection, a very big one. And because he was a very famous Blur points farmer, he noticed that bots were starting to copying his offers, his liquidity offers on the Blur trading platform. So if he were to go and provide liquidity, let's say 1 Ethereum for 1 NFT, all of a sudden other bots would provide the same liquidity, same offer, 1 Ethereum for this collection. So when he noticed this, he started to accumulate certain traits of certain Azukis. So I think it was a specific background color. And then when he had accumulated a vast amount of these NFTs within the collection, he put a huge overprice order, basically paying 10 times or more above what they were actually going for in market price. And lo and behold, the bots started to also provide that same offer. And sneaky, then he withdrew his own offer and then dumped all of his NFTs that he had accumulated into these bots. And I think he pocketed 800 Ethereum doing this. Now, this is, for me, it's a brilliant case of PvP, but is this market abuse or market manipulation? Most likely, right? But so these types of behaviors, not only for Hongwei, but also the bots, they will need to, first and foremost, obviously their actions will not be allowed, but the one that has to implement this and monitor this and have policies towards this are the CASPs, the trading platforms, so the NFT trading platforms. And here is a huge issue I have with this this recital and how NFTs are treated. The example I gave is quite straightforward, I believe. But how are we going to determine, for example, market manipulation or market abuse when someone is bidding on a golden ape and one bidder is giving an offer of 500 Ethereum and another is giving 200 Ethereum, but the floor is currently at 10 Ethereum? It's really difficult to understand where to draw the line for market manipulation here, or market abuse, or giving false or misleading signals, right? Because some of these NFTs, especially the rare ones, they are very liquid. They are, I would argue that those NFTs at least have some sort of sufficient uniqueness in relation to the general collection. And this is represented in the price and of how liquid they are. But still, you know, the CASPs here need to find some way to determine, is this market manipulation? Is this a reasonable offer? And that will be really tricky. And the issue here, once again, is because, you know, we have these assets that are, I agree, many of them are probably more fungible or at least not unique, but some of them could be argued to be more unique and less fungible, but we're treating them all as if they were ERC20 tokens, and all of them are the same tokens. And this is this alignment here with the regulation and the market for NFTs, and that will be very interesting to follow.
So thank you very much. I think you finished, no? So thank you very much. This was very was very much interesting. I think we have a question, but Grant, if you don't mind, I will give the floor to Marina, and then we can answer, or Albin or the other panelists can answer to your question after Marina's speech.
Yeah, that'll be fine. Thank you.
Yeah. So Marina, please, what could have been better in MiCA? What could have been worse in MiCA?
So thank you so much for these presentations and for, again, organizing this event. I'm going to give just a little bit of a flavor of what are all the topics that have been discussed in the last few years. So as you know, the MiCA idea came into place most likely around 2017-18. Some people say even earlier, but it's applicable in 2025, at least the whole part when it comes to crypto asset service providers. So within this time, many things happen in the industry, and that was also reflected in MiCA as well. So just for the start, I don't know if you remember where there were discussions about prohibition of the proof of work within MiCA as well. So that was one part that was pretty interesting. And just to go back to what Viara has mentioned before, how it works in the EU is that usually the European Commission issues one draft, and this is the draft that we've seen, and this is also in a way the reason why EUCI exists, because after seeing this draft, me and my co-founders said we need to do something in the EU, and that was the first one that never had any mentions of NFTs, of DeFi or anything similar, all decentralization. So that was just again the first draft, and then we had two other drafts that came from the Parliament and the Commission. So when we were negotiating, we were talking to all three institutions, and all three institutions have different ideas, different opinions on specific matters. So right now, you know, when I talk to proof of work and everything that you have mostly seen on Twitter, you know that that was most likely the part when the European Parliament was looking into the MiCA draft, because usually that part is more public than usually the part when, let's say, the Commission writes the MiCA draft, and that also shows to MPs often tweeting about stuff, and we had one of this like huge Twitter discussions again around proof of work. So luckily this did not happen. We did not prohibit proof of work or proof of work tokens. So that's why I mentioned it within this event, because that could be some consequences on, let's say, Bitcoin or other proof of work tokens. But there's no difference at the moment. And the only thing that is important for us to know, as it was mentioned before, there needs to be an energy assessment of the token system in written in a way reported within the white paper. So that's pretty important for us to know. And I know that there are already service providers that are working on that, but it was a little bit shocking to see this in the first time, but it is reflecting somehow the values of the EU that are looking into energy consumption as well. I noted somebody mentioned that before, and how much, you know, Bitcoin is using energy right now. I don't know if you're following the AI part. Now the AI is the bad guy, because AI is using so much energy that no one talks about Bitcoin anymore. So we get a new focus for regulators. The other very interesting part is how I see how tokens are issued. So that was, if you think about the whole notion of a white paper and the whole notion of the way how token issuance is regulated, it really goes back to this idea of ICOs. So are we allowed to issue tokens only in an ICO way, which means all the tokens at once with writing white paper at the time from the issuer? Are there any other options or ways how tokens are issued, maybe over the time, maybe some tokens with a help or let's say minting from the user or from different in a way participants within the ecosystem, not only from the issuer? So that was something that we have discussed during the negotiation process, but we didn't seem to find a way of changing that. So we still have this way of, there is an issuance that is happening in an ICO style, which means all at once, and then you write a white paper when issuing those tokens, at least at the beginning. So that's also very interesting. The other part that we have discussed and just mentioned are the NFTs. NFTs were not mentioned in the first draft. We have added them later. There's been a lot of discussions, especially within the parliament over the years. And, you know, first there was a DeFi summer, so we were discussing about that and showing what is the difference between, let's say, a decentralized exchange versus a centralized exchange, looking into why DeFi is important, why we need to look into that, all the numbers around DeFi. Then there was the NFT, you know, craziness. So everyone was reading about NFTs on the media, and that's why they also felt they have to do something about it. When it comes to NFTs, we had different versions. In one version, the NFTs were completely excluded without any other comments. Then later on, we had the comments added that are the ones that we have right now in this version. So talking about in a way, the way how we need to focus on issuance and how many tokens are issued and if they are unique, etc. And then also the part that in a way talks about fractionalization. If their NFTs are fractionalized, they are not excluded from MiCA, etc. So at the end of the day, I know, I think even Paolo, you said that, or someone within the group, we have a kind of an non-definition of NFTs. There's so many things open, as it was mentioned before. So that's going to be really, really fun in the next months, for sure. The other part that is very important when it comes to issuance of tokens is also the recital 22. And in a way, it is important because besides talking about the decentralized use cases and fully decentralized service providers that are excluded from MiCA and not regulated by MiCA, but it also talks about issuers or offerers that are non-identifiable. And in case they are non-identifiable, they should not fall under the title 2, 3, and 4, the ones that we just discussed today. What is interesting is that all the services that are providing services using those tokens, they should and are regulated within MiCA, but not the non-identifiable issuer. I think in this case, we were thinking most likely about Bitcoin, but let's say there are options, there are other possibilities of having non-identifiable issuers. And I think that's pretty important because, again, we did not have that in the first draft. And I would say that this is also a result of, you know, our organization's efforts to include this exclusion. When it comes to decentralized use cases, we have written a few papers around the year 2021 and 2022, and this is when this part was also discussed. Another very interesting part that was discussed within the negotiation process was the reverse solicitation. So basically, in this case, we're thinking if the reverse solicitation could be prohibited from MiCA, because I know that some of the member states specifically wanted the prohibition of the reverse solicitation. And that was in theory not possible later because also from a legal point of view, the reverse solicitation is possible within MiFID. We have reverse solicitation in other regulations as well. So we do still have it at this moment right now in MiCA. But let's say that the thought about having somebody that is not regulated within MiCA and still being able to somehow not really offer, but at least, you know, follow the interest of a European Union citizen when they come to their website on their own or they buy tokens on their own, that was very, very strong of a feeling. I think this is also why ESMA issued the guidance around reverse solicitation. And I would say that they will be also pretty strict in interpreting that, just because we spend so much money regulating these issues. And of course, there are going to be crypto as a service providers and token issuers that are going to follow these rules. And when somebody would like to somehow, in a way, offer these services to the European Union citizens without following the rules, I think, again, those are going to be pretty strictly interpreted. I think that's, at least from my point of view, that's all. When it comes to stablecoins, I would say that not many parts were negotiable or negotiated, just because it's very stablecoin heavy. And as everyone said, that was the main part of MiCA. But I need to say that in the last part, especially when it comes to e-money tokens that are non-euro based and that are used for payments, the limitation there has been included just the last moment before MiCA was closed. So there was almost no possibility of negotiation in that part, because it was really included in the last week before being finalized. And I'm talking about that part where there is a daily limit of how many non-euro denominated stablecoins can be used in the European Union when doing payments. The only good thing that was done in that process was that we have defined payments in a really, I would say, the strictest way possible. So all the transactions that are happening within exchanges and other investments are not included in the payments, but are really just the ones where you use the stablecoin for purchasing goods. I think that's mostly everything that I wanted to cover, but I'm also happy to follow later if anyone has any questions.
Thank you, Marina. So now we have a question from Grant. Grant, can you please read your question?
Sure. Yeah, I'd be happy to do that. My question relates to enforcement, and what I'm really curious about is who's responsible for initiating any sort of investigation or enforcement action. Is it so the example I gave was if an issuer fails to publish a white paper under the applicable portion of MiCA that, like Francesco was talking about, can a member state regulatory agency initiate an investigation themselves, or is it designed so that for an investor would, for instance, an Italian citizen who invested in a project and the white paper wasn't published and they lost money, would they then file some sort of a complaint with the applicable Italian regulatory agency, and that would kick off the investigation? I didn't know if if MiCA dictates who has or gives the right to the agencies themselves, or if that's just left up to the member states. If any of you guys have any ideas about how that's going to play out.
Yeah. So anyone wants to answer? Grant, I think he's a US lawyer, if I'm not wrong.
Yes,
yeah, perhaps I can say something on this. And so we have two levels: the national level and then the supranational level with the authorities ESMA and EBA. And the enforcement is predominantly on the national level. And MiCA encompasses some high-level indications, and then the member states, they implement these indications in providing specific fines for the type of infringement that has been done. And like this was also interesting. I know only the Italian, we have an Italian implementation draft, and so you can see the first fines that can be provided by authorities. And also, like for instance, for ART, there is also jail time if you issue an ART, offer an ART without being compliant. And so, like, the question at a European level is always understanding enforcement, how it will play out, and it's very different than SEC. And I would say that compared to the US, and given that these offerings are also done online, I think that enforcement will not be incredible. What happens today if, for instance, the service is provided from abroad? The authorities have limited power, like they can shut down the website, things like that. But if you don't have a seat in the EU and people in the EU, then the reach of this enforcement is quite weak. But obviously there is a kind of indirect control. One, which I didn't mention before, is the fact that you will have a kind of register of white papers at a European level, and so there will be the possibility for investors that are interested in looking on the and controlling if the white paper is legit or not. And then I think that the control will be provided at a level of VASPs, CASPs, according to MiCA, and so they're going to check, like they're going to be careful in listing tokens that are not legit in accordance to MiCA. But I mean, we will see how it will play out, and predominantly the national level will be the level in which enforcement is provided.
Thank you. Yeah, please.
And then, Francesco, isn't there the exception for the regimes of significant ARTs and EMTs, where it would be the EBA that would take care of supervision tasks, essentially?
Yes, there is this exemption,
but
the
then,
problem is,
yeah,
it is an exemption, and it's also like a bit surprising, because it's, I think, a bit outside of the usual scope that they have. But there is, and the idea is that if you arrive at this level, then you undergo like a European control, because you are so important and so perhaps potentially impactful on the monetary and financial politics at a European level, that you need to be controlled at an upper level. But at the same time, like, I think that for significant CASPs, which is a denomination that is adopted in MiCA, there isn't a special control. And yes, again, I think that national level will prevail when it comes to CASPs and other tokens. If you have this case of significant, then there will be a say also at a European level. More in general, obviously, there will be always like an oversight of the European level, but I think that like this first level of the national ones will be the most important ones. And I would say, like, for the American audience, it's not like an obsessive interventionism as you have it in the US.
To my understanding, at the moment, the registered stablecoins, none of them are significant, so they wouldn't fall under the ESMA or EBA supervision. But maybe something like this will happen in the future, as Francesco said. And there are 30 different national competent authorities. They have very different capacity for any kind of supervision. They have very different capacity for work on MiCA. So that would also maybe help someone if they're thinking of, joining any of those jurisdictions when it comes to at least the first level of discussing any potential licenses there.
Okay. So I don't know if there are other. I have a comment for sorry for Peter. What you were saying that that probably there will not be many e-money tokens or stable coins, European projects. I mean, in my opinion, that's not only a problem for stable coins. I mean, in Europe, it's a disaster. We are only a consumer market for US companies, basically. Now we have this French company, Mistral, who is doing something probably interesting in AI, but I mean, it's really nothing. That's a general problem. I agree with you, but that's a general problem for Europe.
Yeah, I agree completely. And also, I mean, the EU always tries to nurture innovation, but like quite often they fall into this trap of actually creating regulation that kind of just enforces the role of the incumbents. And then we have to take into account that like, I don't think Circle is the biggest issuer of euro-denominated stablecoins, for example. But first of all, we know that on exchanges, nobody really cares if your stablecoin is denominated in USD or in euro. Most people will just use the more liquid pool anyways. And then you have, I think, by tokens issued, Circle is not the biggest. So URC or EURC is not the biggest euro stablecoin, but we have to take into account, I think Stasis, who actually, I think they're also like set up in Switzerland or the Isle of Man, so that's also kind of outside of the EU, but whatever. And you have to take into account that they only issue this euro stable coin, while USDC or Circle has USDC and Euro C, which means that as an issuer, actually their market power is vastly bigger. And if there is instability or if there is weakness, then they can always rely on, it's much easier for them to restructure their reserves and essentially be more resilient than these smaller stablecoin issuers. Even if the actual number of euro stablecoins is higher for Stasis than for Circle.
Yeah, Francesco,
I want to do a comment on this. I agree with Peter. And for instance, the Eurocoin seems more like a marketing initiative of Circle. It's not a product in which they believe, but simply because the trading activity in crypto is done through, it's denominated in the US dollars, and so I don't think that we will see a shift in euro denominated tokens. And I found also a bit ridiculous, like the limitations that exist for the dollars denominated stable coins as means of payment, which is a kind of protectionist measure for the euro. And what I think is problematic from also from a legal point of view is the fact that if we are going to have all this USD denominated stable coins in Europe, for instance, USDC issued by the French EMI, you need to have these holdings in dollars. And what the European banks will do is simply transferring the dollars in the US. So I really don't see which is the upside in having this legislation that in the end imposes something which does not really bring a value to the EU. I think that there the idea was really creating an electronic money token that resembles the use cases of the electronic money, with the idea that there is an interest in having a redemption. But today's stablecoins are not really only this. They are more perhaps something different, which is used for trading and for settlement activities within the exchanges. And so the main recognition is basically not there in MiCA. And what Circle did is important for the industry, but it's I think it does not, let's say, cancel the problems that we have at a European level, and I don't see a growth of European stablecoins, although there are some initiatives that are growing also with the French bank. But to be honest, from the perspective of a bank, I don't see so much the need in doing this, except for showing that you are up to date when it comes to technology and do a bit of marketing.
Marina?
Yeah, maybe what I wanted to add before, during the negotiations, and what's very important is that there's prohibition of interests when it comes to stablecoin and stablecoin holding. And that was also something that was non-negotiable within the process. And that's also, in a way, making it very hard to have a business model around stablecoins. It is true, as Peter said before, MiCA is very good when it comes to incumbents. And, when you are a financial institution, it's just like easier to do anything that is related to issuance or maybe a service providing under MiCA. So in this case, I would think that there might be more banks, European banks, that will go into issuing stablecoins and maybe looking into, I don't know, some of the use of stablecoins within their own ecosystem and basically supporting some of their customers there. But it really is something, as you mentioned, it will be bigger players that are usually US based, and then there might be at least European banks that are big enough to, in a way, follow all this compliance processes in order to issue stablecoins.
Peter?
I just wanted to say, I agree with what Marina said, and also, I guess an optimistic way to look at it is that if stablecoins actually become like a very useful tool for settlement of transactions, well, all of these European banks, they are really not happy about having to be part of Visa and MasterCard's ecosystems for retail payments, and essentially they're not happy about having to pay those fees as essentially issuing banks of cards or acquiring banks. So if they can have a viable alternative to, you know, account to, well, payments essentially, that doesn't need to go through this whole network of these card schemes, I think they will try to get out of that. So that might be something that's an incentive for them to create stable coins. And actually for Visa and MasterCard, if stable coins turn out to be like a great a great tool for settlement, it's possible that the current settlement infrastructure is going to be reshaped to be more accommodative of essentially stable coins. If Visa and MasterCard realize that this is something we can't fight, so we might as well just join it. But this is, in a way, well, not optimistic. I mean, it depends on your perspective, but it's an out there perspective, I guess, or it would be ambitious to say this at this moment.
Thank you. I have a question for Francesco. Do you want to say something?
No, sorry.
No, maybe it was all. I have excuse me. I have a question for whoever wants to answer. What is, in your opinion, the impact of the stable coins on the e-money institute and the payment institute in Europe? I mean, there are a lot of, and now for professional reasons, I'm working with the Italian institution of e-money institute and payment institute, and at least in Italy, most of them are really small companies, are just SMEs basically. So given the scenario that you're giving, what would be the impact, in your opinion, on this army of SMEs that have their own market in digital money? Let's use this word in a technical way.
I think the best would be to look into what were the consequences of MiFID. We have discussed with, people that were working with MiFID at the time, and I think that there's going to be a lot of consolidations. A lot of bigger banks, bigger institutions are already looking into maybe acquiring some of the startups, SMEs. There might be mergers, etc. So I think we'll see something we'll never seen before within the crypto industry, because it's just going to be the first time that we have a regulation that was, within an industry that was never regulated before. Maybe the closest that we had was in France, but the whole other part of the EU will be completely new.
Alvin, please.
Yeah, and just to build on what Marina is saying, from not only maybe a stable coin perspective, but in general, I was talking to one of the major success, so one of the top 3 centralized exchanges today, and they told me, well, we have already been approached by several smaller exchanges that want to be acquired by us, because compliance will kill their operations basically under MiCA. The profit margins will, and some of these are teams with 60 people, and yet they don't still believe they will survive. And I mean, in Sweden we have even smaller exchanges. So the consolidation is, I fully agree with that assessment, and not only in the stablecoin part of MiCA, but I think in the overall industry will consolidate within Europe.
Grant, please.
Yeah, thank you. I have what I think is a positive comment, just my takeaway from a lot of this, and this relates to the types of clients that I often work with. What I see MiCA as providing, and I'm curious if you guys agree, is really a compliant path to do, for instance, an ICO style public sale, as long as the issuer is willing to follow all the requirements, assuming it's something like an other token, as Francesco described, and do publish the white paper, have it register it or present it to whoever the member state that signs off on it, and then and follow all the guidelines, as long as they would obviously exclude US residents and perhaps just allow EU residents to participate. To me, it looks like it's really offering a compliant path forward, which is something that, we certainly don't have in the US. Do you guys see it that way, and as potentially a market opening up for, sort of a resurgence of ICO style raises that are just focused on the EU?
Yeah. Anyone?
Yeah, I can. I mean, I fully agree with you, Grant, and I think the winners here are actually the other the other tokens. I think CASPs are it's a game changer for them basically, and it's very compliance heavy, and not only just one-off, ticking off the license, but reoccurring compliance and especially AML. So they are losers to some extent. ART and e-money tokens are also, I think the regulation there is very strict, but for other tokens, I think it's very straightforward. And I mean, there's so much leeway for these tokens. I mean, if the offering is under 1 million euro, you don't even need to have a white paper. So I think they are the winners here.
Francesco and Marina, then.
Yeah, I also want to say that with this framework, it is possible to dream about big ICOs as in the past, like EOS style indications. For more serious providers, there is the possibility of doing it on primary sales. And I think that it would be great because in the end, it brought a lot of scams, but also a lot of innovations, the potential of raising funds in this way, which will be easier than what happens in traditional markets. Because like what is really different, in my opinion, is the fact that you don't need to demonstrate a particular track record for the company that does the fundraise. And so it's really connected to an idea that you provide, to a platform that you provide. And this is something which can bring back this very crypto style fundraise, and I hope that many will try it. And also, I think that we will see that more serious projects will invest in a white paper, and that's also, I think, nice because it will be a demonstration of seriousness, and it will really help investors also to distinguish between projects that are scams and projects that are more serious, because the investment in this legal requirement is not incredible, and so it will be affordable for many, and it will open up a lot of opportunities in Europe.
Marina?
I would just quickly want to compare it maybe to crowdfunding. We do have a crowdfunding regulation in the EU. I was working in crowdfunding 8 years ago before joining crypto, and the problem there is that it was very, even if it was loan or equity related, it was very subject to the national market. So no one wanted to invest in a project or support a project that was outside of their own market. And I think that right now with ICOs, we have really showed that this could be global projects. And I think that we will have a European Union market for supporting ICOs, for investing into ICOs, and definitely more successful than crowdfunding that we had before. So I really hope this is going to be a great opportunity for a lot of projects, and also accelerators, some other incubators that are working on those projects in Europe.
So, any other comments, questions? No? Okay. So I would say we can, it's also almost 2 hours, so I would say we can really close this session. I would really thank you everyone here, all the panelists, for coming and for very interesting discussion, and thanks to Grant also for being here. So I do hope, and I hope that this was an interesting more than introduction, I would say, interesting, really in-depth about the regulation, the treatment of token assets in MiCA. So this, as I said, it's going to be published the next weeks in LexDAO YouTube channel. So thanks everyone, and you're also, behind myself was LexDAO, a DAO of lawyers and legal engineers. Okay, thank you everyone, and good night here in Europe. Bye. Bye.
Thank you.
Bye bye. Thank you.
Thank you.